Hi, and welcome back to Hill and Ponton's Veterans Disability Blog. I'm Natalia Joffrey, the company's COO.
And I'm attorney Ann Lynn Scott.
Today, we're going to be talking about TDIU.
Correct.
And what does that stand for?
So you'll hear, it's the same thing as IU. You'll hear IU, unemployability, TDIU, it all means the same thing, but TDIU, the long version is total disability based on individual unemployability.
Okay, why is that important?
So that's important because total disability, so 100% disabled, is the highest rating that a veteran can get either for one condition or multiple conditions combined. And the way that I use quotation marks for VA math, because the math, the way the VA combines ratings or rates conditions is not always the most straightforward. And getting to that 100% through the ratings themselves can be pretty difficult.
That's so unusual because everything with the VA is always so straightforward.
Right?
So how does that happen,
Keeping
right?
with the theme. So with TDIU or unemployability, it's kind of a more straightforward way. You can get the 100% benefits, you're considered totally disabled, but your actual rating might not be 100%.
Okay, so who can qualify for TDIU?
Any veteran with a service-connected condition who, because of that service-connected condition, cannot work. And there's a lot more into that one statement, but that just quick and easy, that's who would be entitled to it.
In a nutshell.
Yeah.
Okay. So I'm a little confused. And so I want to see if I'm understanding this correctly. So if you get TDIU, is that like skipping all of the other steps? Because I know that lots of times people get like 10% and then they get increased to 30 or 50, and then eventually years later they get increased to 100. Can you get approved for TDIU and skip all of those steps and you get just as much as from TDIU?
Yes. So
Okay.
if a straightforward example would be if a veteran is service connected for PTSD and their rating is 70%. They have no other conditions service connected, so their combined rating is 70%.
Okay.
If they apply for and then get granted TDIU, even if that 70% rating doesn't change, they are considered totally disabled. So that's where saying the name out, TDIU, actually kind of helps explain the situation. They're totally disabled or 100% based on their inability to work.
On their unemployability.
Correct.
If you will. And so that would then, in my mind, equate, and you let me know if this is correct, that they're going to get a benefit that would equal 100% disability.
Correct. So their monthly benefits, the compensation amount is the same amount as if their rating were 100%.
That helps. Thank you. Okay. Okay, so the benefit amount is the same for 100% disability benefits as TDIU.
Correct. So if you're granted TDIU, just think 100%. That's it's right around $3,000 a month. There's no distinction between a veteran who's getting monthly benefits because their combined rating is 100% and a veteran who's getting TDIU benefits. Their monthly compensation amount would be the same.
Is it easier or does it take less amount of time to get TDIU than it does to get, a 10% increases or whatever?
I wouldn't say easier, but maybe more straightforward, especially with conditions such as orthopedic problems, back ratings, just the way that the VA rates those specific conditions can make it hard to get to the 100%.
Right.
Or in other cases where a veteran has multiple different conditions, the higher their combined rating gets, the harder it actually becomes to get to that 100% combined rating. So with TDIU, because though you're not dealing with the rating criteria or with the VA math, it can be more straightforward to get that 100% benefit level.
How do you make the decision then, or the distinction between, because it sounds like you're either you have to choose a path, is that correct?
You don't necessarily have to choose a path. So a lot of times I'll tell veterans, options are great. They can definitely make things more complex sometimes, but there's plenty of times where we've argued that a veteran is entitled to a 100% rating schedularly or through the rating criteria. And in addition to that, they should be considered 100% disabled because of unemployability. You wouldn't get over the 100%,
Right.
but you can make, it's kind of 2 bites at the apple.
Okay, all right. So I guess that's where your expertise comes into
Yes.
play, right? So you don't have to make a decision at the beginning of the claim and say, okay, this is the way we're going to prove this case. You
Right.
could be halfway in it and realize this is the way to go,
Right.
depending
And
on what you have.
With TDIU applying for that, we oftentimes recommend putting in, there's a form that the VA requires, the 8940, you'll hear it called, as far as the regional office basically requires that to process it as an issue. This is where it can get really complicated and tricky because it technically should be considered as part of underlying claims. So if the veteran files a claim for PTSD and increased rating, the VA should also be looking at, is there evidence that the veteran can't work because of this? But we often recommend get that form in right away so that the VA there's no question that this is an issue that you want to be raised, that you feel that you can't work.
Okay, great. So how do you prove TDIU?
Similar with, medical evidence is definitely important, but TDIU is a little different in that medical evidence can establish symptoms, limitations, doctors can comment on that. And TDIU, you want the evidence to really explain, because of those symptoms and those limitations, that keeps you from working. So some evidence that's very strong in cases, vocational experts. Social Security on that side, I believe actually as part of the claim process, they get vocational experts to review the case. The VA doesn't necessarily do that. They'll have C&P examiners comment on functional limitations, but what's really needed a lot of times to kind of tie everything together and provide a thorough explanation of the impairments that a veteran's condition causes is finding a vocational expert to review all the medical records and provide that kind of evidence.
Because you mentioned Social Security disability, which is near and dear to my heart.
Yes.
I feel compelled to ask. So if a person is receiving Social Security disability, and so that with Social Security disability, there are no percentages. There's no 10% or 30%. It is 100%, if you will. You're either approved or you're not. You're either on benefits or you're not. So if a veteran has been awarded Social Security disability benefits, does that help their claim, or could it assist in their TDIU claim?
It definitely helps. There's nothing that says the VA has to grant TDIU benefits because a veteran is on Social Security benefits as well. But it's great evidence to show the limitations, especially if they're on Social Security disability for a condition that's service connected.
Right.
That right there is, it's strong evidence.
Yeah.
Sometimes we still would recommend getting additional evidence to explain that, depending on case specifics, just why the VA is denied unemployability. But Social Security evidence is definitely helpful.
Yeah, I just feel it's important to mention, because a lot of times people lose out on benefits thinking they have to pick one over the other, that you can get Social Security disability benefits and veterans disability benefits. Now, we're not talking about SSI, which is based on income, and we're not talking about non-service connected benefits, which are also affected by income. But as far as regular disability goes, which you've worked and paid into the Social Security system for, and service-connected veterans benefits, there is not an offset. People need to know that you can apply and pursue claims for both and ultimately get both benefits.
Right, and you can, it's also important to know that even if you were denied for a Social Security claim, that doesn't necessarily mean that you can't get TDIU benefits through the VA. The standards are completely different.
Yeah. Since we're talking about Social Security, which normally requires you to not be working, can you work and get TDIU benefits?
So that's one of the biggest differences in how I said the standards are different.
Yeah.
Yes, you technically can still work.
Okay.
That's a very short answer to a huge question, but the VA, especially at the regional office level, treats it as very black and white. So there's going to be a lot of cases where you apply for TDIU benefits, maybe you're working, but it's part-time, or you're working and it's for a family business, some kind of sheltered environment. The regional office, a lot of times we'll see, oh, the veteran's working, moving on, deny.
Okay.
But the regulations and the law states there's more to it than that.
So it definitely introduces a significant complication into the claim.
Right.
Yeah.
So it makes it less straightforward, but not impossible by any means.
Oh, okay, good. Is TDIU permanent? I know you get that question all the time.
Yes. So similar with how the percentage ratings work, it can be permanent. It can also not be permanent. So permanent basically means the VA acknowledges that things aren't going to get better. You're not going to improve. So for TDIU, typically speaking, they kind of go hand in hand. If the VA grants TDIU benefits, they say it's permanent. There are cases where they don't say that it's permanent. A lot of times, if a veteran's been out of service for less than 5 years, age is not a factor for eligibility to TDIU, but it can sometimes be a factor as far as whether or not the VA is going to consider TDIU benefits permanent.
That's funny that you say that, because that was my next question. How does age come into play, and does it affect TDIU?
So age comes into play, like I just said, the VA regulations say that they cannot consider as a factor to determine if a veteran is eligible for the benefits.
Okay.
So a lot of times I'll get veterans calling in, prospective clients saying, well, I'm 75, of course I can't work, or, I retired because of my age. And there are definitely times when, the VA might incorrectly look at that, but the regulations say that age is not supposed to be considered a factor in determining eligibility for the benefits.
Okay. When should a person apply for benefits?
So going back to, I brought it up a little earlier in our conversation, but I recommend as early as possible. I mean, there's cases where a veteran comes to us trying to apply for service connection for PTSD, and we're handling that appeal, and we already know, well, they can't work because of PTSD. So we'll go ahead and file the evidence and the forms that the VA requires for TDIU benefits just to get the ball rolling. It's not going to get granted until conditions are service connected, but that way the VA is acknowledging it, is on notice that it's something that the veteran is ultimately going to be applying for, and sooner the better, then you don't have to remember to do it later.
Okay, good. How do they apply?
So this is another tricky, I say tricky because of how the regional office handles TDIU and what the law says. To apply for TDIU, the regional office will require the 8940, the VA form 21-8940. Sometimes they'll also require the form for new claims, the 526. But technically speaking, if there's a claim going on for service connection or increased rating for an already service-connected condition, if there's evidence in the file that the veteran can't work, the VA should address the issue of TDIU on their own. It's always best, though, to just make it as clear as possible. It's the VA. I always say you have to choose your battles. So get the form in, make it clear, and then that way you're not having to rely on the VA to find that issue.
Okay. Just because it was one of my questions, no penalty, right? Going back to the Social Security and TDIU, like with any other veterans, service-connected veterans disability benefit, there's no penalty to get both.
Correct.
None. Okay. Common issues with TDIU. Concerns, what would you put
There's
out
a lot. I would say one of the issues is what I just said, how the regional office treats it versus how it really is supposed to be treated. And that's, again, they'll treat it as a separate claim when it's really supposed to be inferred with the underlying issues already on appeal. That's probably one of the biggest in that. goes to effective date as an issue. So you might find in a lot of cases the veteran files that form, the 8940, they'll get granted TDIU benefits, and the VA puts the effective date as the date that form was received. Whereas there's a lot of different regulations and rules where it should actually go further back. So we're talking about a lot of retroactive benefits that could be at stake.
And when you're referring to effective date, you're referring to what? What does effective date mean?
That is the date that the VA says a veteran is entitled to those benefits. So starting that date, they get the increased, they're being paid at 100%.
Pretty important date
Yes.
to mess, so you don't want to mess that up.
Another one is that it all kind of ties in with effective dates, but when the VA, if there's evidence in the file that the veteran's not working, the VA doesn't address it how they're supposed to, doesn't develop it the correct way. So, or when we started out talking how it's not a blanket no if a veteran's working.
Right.
Common mistake is that the VA will see a veteran is working and kind of stop looking there and just deny, where they really need to look at the circumstances of the work.
Okay, all right, great. And this was so helpful. Thank you so much. If you have any questions, feel free to call our office or visit our website. Otherwise, thanks for joining us, and we'll see you again next time.
Thanks.
So when you're filing for individual unemployability, do not put every single condition on there unless you're being affected by all of them. If you have 70% for PTSD, and then you also have diabetes and peripheral neuropathy and hearing loss that add up to 60%, and you feel that you can't work solely because of that PTSD, only put PTSD on the individual unemployability, because then you're setting yourself up, like Stacey said, to be able to get that SMCS. So you have to have one condition that fulfills that criteria. So 60% rating for a heart, 70% for any mental condition. Kidney conditions, I see you can get 60% for where you have like chronic kidney disease, and that can be your one condition. So that's kind of what she's explaining, is that it has to be one condition.
So according to the regulations, a veteran who is not capable of substantially gainful occupation is eligible to receive payment at the 100% rate because of total unemployability. However, within the regulation, it also qualifies that by saying that marginal employment will not be considered substantially gainful occupation. And there's a lot of gray area there as far as what that means. Within the regulation, it does specifically say that there is a financial threshold to it. So marginal employment will be considered working under the poverty level. And that's pretty much the only clear line there is there. So you can pull the employment records. If there's a veteran who is working a few hours a week, or just a little bit of time, and the VA has said, nope, TDIU is off the table because of employment, you can pull the employment records and look just strictly at the finances and what the veteran is making and prove marginal that way. But there's also some ways to prove it when the veteran is working above that financial threshold. So let's talk a little bit about that.
Yeah, so when we talk about marginal unemployment, the courts have said that if it's marginal, it's not substantially gainful. And so that's really what we're going by. And VA kind of has two ways of looking at marginal employment. One is whether or not the veteran is making under the poverty threshold. And like you said, one of the easiest ways to prove that, pulling Social Security earnings records, taking a look and seeing where they stopped making any kind of substantial income or over that threshold. Now, for some veterans, they may be making over the poverty threshold, some substantially more, some just over. But that doesn't preclude marginal employment either, because VA also looks at whether a veteran is in a sheltered work environment. That's also considered marginal. So there are two ways to kind of prove that marginal employment if you are making over the threshold. One of the issues with the sheltered workplace or sheltered protected environment route to go is that we really don't have a definition of what a sheltered and protected work environment is. The courts have not been consistent on when they're granting or not granting based on certain types of situations. So one veteran can have the exact same situation as another. One may be granted, one may not. And so it's actually going up through the court system now on what is that definition of a sheltered or protected work environment. I know, with COVID and the pandemic, a lot of people's work environments changed. And so working from home before may have been an accommodation given, but now it's given to so many people, it's so much harder to prove. But it doesn't mean that if you're making over the poverty threshold, that you still may not be entitled to those TDIU benefits. One of the other things just to consider when it does come to that protected and sheltered work environment is that once TDIU is granted, even on those grounds, VA each year will pull a Social Security report. And if it shows that you're making over the poverty threshold, they're going to send you a letter. And that letter is usually, we need some financial information, you're making over the threshold, and if you are actually making over, they will send out a proposal to reduce your benefits and to sever your unemployability, even if it's granted by the board or the regional office based on a sheltered and protected work environment. I recently had that happen with one of my vets where the board granted under a protected work environment. He got his Social Security earnings pulled. They sent a letter. We drafted a letter, sent it in, and said, hey, he was granted, nothing in his working environment has changed. He's not making any more money. It's the exact same situation, and VA still severed. And so right now, he's not receiving those unemployment benefits. He's only getting his normal compensation for his rating, and we're trying to fight it. And there's a gap in the money that he's due. Yes, he will get that retro when we reinstate it, but these are definitely challenges and things to consider because VA does get this wrong all the time.
Yeah, that's something that's really important to actually make veterans aware of in the context of, yes, so maybe you've already overcome that hurdle and proven that the employment that you're still doing is marginal. Know that the VA is going to keep reaching out to you and they're going to keep requiring you almost to prove it all over again. So don't fall back and become complacent in thinking that there is nothing else that you're going to have to do in order to keep those benefits, because there is. And as Ursula was just pointing out, it could result in having your benefits severed if you're not paying attention to that and providing the information that the VA is looking for in order for you to be able to keep it.
And I do think that once the cases kind of make it through the court system and back down, and we actually have a definition of what that is, and we can take it and look at it and apply that to our vet circumstances, it's going to make it much easier to know which of these are actually marginal employment through a sheltered workshop or protected work environment.
So the technical language here is protected environment. A protected environment includes sheltered employment, but a protected environment is also bigger than that. This person, their protected environment would be the fact they work for themselves. They determine their own hours, they determine what they do, they don't have to listen to bosses, they don't have to, be in their desk for a certain amount of time. So you can be your own employer and have a protected environment, because what it comes down to is, could they work any other job in the economy? Could they work in a YouTube job for somebody else if they had to work for somebody else and show up for a certain amount of time or certain hours? So that's something I think you can do.
In your situation, I would apply for TDIU. If you feel that you're, I'm assuming again, A&D is anxiety and depression is what's causing it, then you need to go ahead and focus on that. Never let the fear of a reduction get in the way of a valid increase, okay? The difference between 70% and 100% or unemployability, especially if it's permanent total, is night and day, both monetarily and the secondary benefits you get. So if you're not working or cannot keep a job due to that, I mean, Carol, this is where you and I agree on your part. I always say appeal and put that claim in. We agree?
We agree. Absolutely.
People-
How about that?
People-
That's
this
twice.
is-
So I'll start with TDIU. TDIU stands for Total Disability Due to Individual Unemployability. And so I'm going to refer to that as either TDIU or IU. And ultimately, for anyone who's not familiar with the term, it is when you as the veteran are able to be paid at the 100% rate, even though your combined individual disabilities are not or do not total a 100% scheduler. So ultimately, it is when the VA looks at either an individual service-connected disability or the combination of all of your service-connected disabilities, or even just some of them, and determines that those disabilities and the limitations that they cause for you result in an inability to perform substantial gainful employment. When you are filing for unemployability, technically, the way that the VA interprets or should interpret unemployability is that it runs with any of your service-connected claims. So ultimately, the VA is to assume that you are always applying for the highest rating that you can receive for your disabilities that you have claimed or that are on appeal. So ultimately, if there is evidence in the file that shows that you are unemployable, the VA is supposed to address a claim for TDIU as well as your other individual claims. Now, oftentimes the VA doesn't do that unless you file the technical form for filing for unemployability, and that is the VA Form 8940. So when you file that form, what you are looking for is to identify any or all service-connected disabilities that you believe result in an inability for you to perform work. So a little bit of a caveat there is what the VA has been doing with these forms. Ultimately, when the veteran lists those service-connected disabilities, the VA goes and schedules exams to evaluate all, if not most, of those disabilities. And so what you're going to want to do is I think, limit a little bit as far as which disabilities you are claiming, in that if some of them are not causing limitations that you necessarily think are resulting in an inability to work, you may want to leave those off so that the VA doesn't go in and reevaluate those, because ultimately, as I'll talk about later on, that can result in the VA proposing to reduce if, for whatever reason, that examination comes back with findings showing that you might be, the severity of your condition might have improved. So anyway, what you want to do on that form is list your service-connected disabilities. You want to limit it to your service-connected disabilities or disabilities that you are currently claiming or have on appeal that you believe will ultimately be determined to be service-connected. You don't want to list non-service-connected disabilities, because that's one of the reasons that the VA will deny unemployability, is they will determine that, yes, you aren't able to perform substantially gainful employment, but that some non-service-connected disabilities are causing that unemployability, and that it's not completely due to service-connected disabilities. So that's one tip, is to make sure you're only identifying service-connected disabilities or those that you believe will be service-connected, and then limiting it to those disabilities that you understand may be reevaluated after the VA receives your 8940. One of the other tips as far as filing for unemployability and providing the VA with the evidence that they are going to be looking for that will help you to win on your claim is that if you have been determined disabled by the Social Security Administration, you will want to make sure that that information is contained in your filing. And ultimately, if you are able to, if you have access to those records or your favorable Social Security determination, you may want to provide that to the VA. Now, again, going back to what I just was talking about as far as service connected versus non-service connected, if your Social Security disability was granted based on all non-service connected disabilities, that determination probably isn't going to help you much as far as proving your unemployability. You're going to need different information related to your service connected conditions. But if you were granted Social Security disability benefits as a result of service-connected disabilities, then that information can be helpful for the VA in order to show your unemployability as a result of those conditions. Also related to Social Security information, the VA is going to want to know your work history. You are entitled to receive unemployability effective when you stopped working at the substantially gainful level. Now, that's a level that is predetermined in the regulations, and it's essentially as long as your earnings are under the poverty level. And when VA is looking for information about your employment on that 8940 application, they ask for you to identify your work history. If you provide them with your Social Security earnings records, which are something that you have access to through the Social Security's website, you will need to register for a login into your own, into being able to access your own benefits. But once you've done that, you can go in and you can print out a copy of your Social Security earnings records, and you can provide that to the VA as proof of approximately when you stopped working or when you stopped working above that level that they consider to be substantially gainful employment. So often the VA is going to consider your claim for unemployability to start on the date that you file that VA form 8940. However, if prior to that you have had claims or appeals pending where you are looking for entitlement to service connection for conditions that limit your ability to work, or if you are looking for increased ratings on service-connected conditions that limit your ability to work, your claim should go back to either as far back as when you filed those claims or when you stopped working. So that's why those earning records are going to be important in order to show when that time was. But also just so that you are aware that you may be entitled to benefits prior to when you actually filed that 8940. The last thing that I have to share as far as filing for unemployability is that in addition to that Social Security evidence that I was talking about earlier, so the Social Security earnings records and any information regarding Social Security disability that you may have been granted in the past, the other thing that you're going to want to try and provide if you can are statements from your doctors regarding the limitations that your service-connected disabilities cause for you. And by limitations, I'm specifically referring to limitations that would prevent you from being able to work. So limitations with sitting, standing, walking, using your hands for pushing, pulling, fine manipulation, all of the things that go along with working. In addition to physical limitations, we're looking for mental limitations and cognitive limitations as well. So the inability to pay attention and to pay attention or inability to maintain concentration. The need for breaks if your physical or mental condition are causing you the need to stop and take a break, things like that. So if you have a physician who would be willing to provide those limitations, that would be really helpful. The VA is going to send you for examinations and ask their doctors to provide some limitations. However, oftentimes those limitations are not sufficient in order to prove unemployability. So the more information that you can get from your doctors, the better. Additionally, if your doctor is willing to go on the record and say they believe that whatever your limitations are, either physical or mental, are causing you inability to work, that's very helpful as well. If your doctor won't go so far as to say that, then you can also take those limitations and they can be provided to a vocational expert. So an expert who has experience with understanding what the requirements are for working. And that's what we do, is we take those physical and mental limitations that are provided by doctors and we provide them to vocational experts who will provide an opinion and let us know whether or not those limitations are significant enough that you are incapable of working, or if they can't offer that opinion, one way or the other. But those limitations by your doctor are going to be what help to determine whether or not unemployability is available.